Thanks for having us. My name is Gary Harshman. I'm Administrator of Probate Court. To my right is Valencia Hunt. She's one of our accountants, which does her duty. She does all the external accounting that comes to us. She's the one who audits those and gives you the exceptions if needed. And to my left is Polly Agee. She is actually with Douglas and Greer Insurance Company. They do probably 90+% of the bonds that's written in probate court. We've had a bond through the probate. You probably dealt with Polly. We're going to start out this morning, or this afternoon now, with Valencia kind of giving some of the how to file accountings, the do's and don'ts, and some of the, I guess, most popular exceptions. Feel free anytime if you have questions. We'll be happy to answer them as we go, or you can wait till we're finished and we'll have a time to open up for all questions. Okay? Valencia, go ahead.
Okay, starting off with a few important things you need to know about filing an accounting. With conservatorships and guardianships, the first accounting will be due 7 months after a personal rep is appointed. So the accounting should be for 6 months, but we give you 1 extra month of filing. So it'll be due 7 months. With the states, the first accounting is due 15 months after the personal rep is appointed. And then after that is a year after the first accounting, 15 months is filed, then after that is a year annually until you close it. All the annual accountings should be 12 months only. They shouldn't go over 12 months. If you go over 12 months, I'm going to give you an exception for that. So all annual accountings 12 months only. Interim accountings are accountings that are less than 12 months. So if you're filing an accounting that may be just like 7 months, that'll be an interim accounting. Final accountings, they are accountings that are 12 months or less. So if you're about to close it, that will be a final accounting. And it has to have a zero balance. If it doesn't have a zero balance, then you'll get an exception for that. Let's see what else. Okay, even if the estate, the conservatorship, or the guardianship, even if it was no assets yet, you still, unless you got the accounting way, you still have to file an accounting. So don't think that, I don't have nothing yet, I haven't got any money, so I don't have to file an accounting. You still have to file one. It's just going to be a zero accounting that you're going to be filing. And in the office, we have a form that's called the Clerk's Report form. It's also online. So on that form, I really prefer, I need y'all to write the dates that the accounting consists of on that form to make it easier for me to see it, so I won't have to go back and look. So write all the dates on that form. And as far as I'll tell you some of the common exceptions that we usually have. One would be surety statements. If you had no surety statements. If you had when you open up the state, if you had to get a bond, then I'll need a surety statement for that. If the bond was by Polly and Douglas and Greer, which most people get their bonds with Polly, if it was that, I can get the bond for you. I can get the statement. But if it was with someone else like Boyle or any other surety company, you need to get me the surety statement, or else it'll be an exception. Other common exceptions would be not having bank statements or whatever statements that, whatever accounts that the state had or the conservatorship. I'm gonna need those bank statements, especially to see, the ending balances to make sure everything matches up. The accounting has to be signed and notarized. And it should be signed and notarized by the personal rep. If it's more than one personal rep, then both of them needs to sign it. It can't be signed by the attorney. If it's signed by the attorney, you're going to get an exception for that. Past due court costs, you can get an exception for that. It used to be $50, it's $25 now. So if it's over $25, you're going to get an exception. It can be open over 3 years. If you file an account that's been open already over 3 years, you'll get an exception. And you'll have to, based for that, you really can't clear that exception. You really just don't need to go to the hearing and tell the judge why you got that exception, and then the judge can overrule that one. You'll get exceptions for no receipts for disbursements. Like if there was an error that if you had to distribute money to heirs, I need to basically know that the heirs got their money. So the heirs need to either sign a receipt, or either you can show the council check, like where the person cashed their check. Overspending, whatever with conservatorships and guardianships, you have to file your property management plan, and that's what tells me how much you are allowed to spend. So if you overspend it, then you're gonna get an exception. And I am gonna add it up, so don't overspend. You'll get exceptions if you pay attorney or personal rep fees without court approval. You can't, well, you don't suppose, well, the only way you can pay, attorney fees or personal rep fees without court approval is if you get all the heirs to sign a receipt saying they were okay with you paying the attorney. Otherwise, you have to get a court order before you pay that money. Pay expenses on real property without court approval. This is basically for estates. You can't sell homes or any property without court approval. So after the first 4 months, you're not supposed to pay any expenses on real property. So if you do after that first 4 months, you're gonna get an exception. Ending balances. The ending balance has to match to a T what's on the bank statement. So even if it's like, well, if it's maybe like $5, so I may let you go. But it needs to really match exactly, because the judges, when they look at the county, they're gonna look at it, and so if it don't match, then they're gonna bring it back to me. So it needs to match exactly what's on the bank statement, your accounting. The beginning balance needs to match. The beginning balance of the new accounting needs to match the ending balance of the last accounting that you filed as well. If that doesn't match, then the whole account is going to be thrown out. So you can get an exception for that. And one of the last ones is the certification as to notice of accounting form. That's what you found. We have that in the office if you're unfamiliar with it, and it's online. That's the form that you have to list all the heirs on there, and that's the form that you send to the heirs to let them know the date that they have to object to the accounting if they see anything wrong with it. If you don't have that accounting, if you don't have that form, and if all the heirs are not listed on there, then you'll get an exception for that. So that's pretty much the main do's and don'ts that I have. Are there any questions?
No questions. I think on the property management plan, we've got different categories, say utilities. You add it up for the whole year, right, and kind of average it out when you check the accounting.
Well,
sometimes utilities may be a little bit more this month, a little bit less. So you just basically add it up to kind of average it out.
Right, like most times in the property management plan, it'll have like kind of total, most people have like a total monthly spending. So like if you went a little over on utilities but didn't go, a little under on cable, I would let that go, as long as you're not going over that total month that you could spend.
But she does it by year basis. She's gonna do the whole year. If you're under, you're good. So you could be out 1 month and short the next month, over 1 month, short the next month, and all averages out. So it will be off the yearly spend.
Okay, that's what I was thinking.
Lindsay, are you handling, how are the status reports being handled? Is that, I know you're generating, I assume you, I'm not sure how the emails, the citation emails are generated, but will the status reports be a part of that if someone were to miss the status reports? Is that going to be kind of your wheelhouse as well, or?
I'll take that. Not necessarily, because the status report does not have to be county does not have to be approved on that. It's just a report that comes to our office. It will go out right now until we get our computer system set up to handle it differently. Right now, if you have an accounting way and you're required to do a status report, you will get an accounting citation sent to you. And we know that's probably going to happen. You're going to call us up and say, hey, this was waived. And then at that point, we're going to say, yes, it was waived, but you do a status report. So right now, it would be treated just like an accounting, except for when it comes in the office, it would just be filed and not auditor has to come back to approve. Okay. And I did want to touch on a couple of things that, when we say on the first accounting you have 15 months, that's for a 12-month period. It's from the day it was opened through 12 months. You get 15 months to file it, so you have some leeway to get all your documentation in your office or to you or from your clients or whatever. So it goes, that period every year that same day. So if your accounting due date is December 31st, 18. It's going to be December 31st, 19, 20, 21, and so on until it's closed. That does not change, but your 12-month period is just kind of like the way I explain it to everyone who gets a little confused. It's just like your income tax. January 1 to December 31st, you have April to get it filed. If you file an extension to that, doesn't mean you have more time or more months that you can file. It's still through that 12-month period. They're just giving you more time to file. Come next year, you're still supposed to have that filed by April 15th. We'll get another extension. That's really the same way our program works. You have till that date. So, and our new system, and with our old system, I know a lot of you guys have been doing this a long time, and our system, when we changed a due date on an accounting, it changed everything. Our new system does not do that. It actually keeps it the way it should be kept. So if you come in and get an extension for a year to file your first accounting, for example, well, actually, that year's up. You're due 2 accountants. You're 24 months behind. So, and that's why you'd have to file it. Catch up 2 12-month periods to catch those accountants up. I would suggest anytime you guys go past a year of an extension on any accounting, that you put on your order to extend all accountants. Because what can happen is if you extend that first accounting a whole year, say for whatever reason they allow you to extend that a full year, when that comes due again, you're actually going to have 2 come through. If you come back in and only file an motion to extend that first accounting again for, say, 3 months, well, that does not extend the second one that's due at that point, too. So if you go past a year and you're doing another extension, make sure you put on your order to include all accountants that could be due. Or you're still going to be due. You may be okay on the first one, but now you're past due on your second one. You don't have any other questions on that?
I have a question, not necessarily now, but still on accounting. I have a couple of cases where the judge has required that an accounting be filed but not audited. What do I need to do on that when I file it? Do I let you know? Or?
Yeah, you let me know and I'll go back and look at the order, and make sure myself. But yeah, we basically just file it and then I'll just write on there, do not audit, and we don't audit it. Also, the clerk's office can't extend any accountings anymore. I think we used to, you can call us and like, can I get a 30-day extension? But we don't do that anymore. So you have to go to the judge and do a motion in order for your to get your time extended to file an account. Any other questions?
Okay. Well, this time we're going to turn it over to Polly and let her kind of give you some do's and don'ts about bonds.
I am Polly Agee. I am with Douglas and Greer, and as Gary said, we do the majority of the bonds in Shelby County and the surrounding areas. I'm going to just put out some very basic information, and then I'm going to talk to you about a few pet peeves that I'm running into right now as I work on a past due list. If you are coming to court for the first time to open an estate and say your client lives in West Memphis, say your client lives in South Haven, it's considered out of state and most likely you're going to have to post a bond. It is best if you pre-qualify your client before you come to court because they have to be able to pass a credit check in which to be bonded. The minimum is a credit score of 600, but the higher the bond amount, the higher the credit score needs to be because I'm looking not only at the score itself, but how they spend money. Are they a good risk for us to bond that money to make sure that it's going to be, if something goes wrong, that we can make it whole again. And we've done everything necessary to prevent a claim from happening. And so, you can call me, you can email me. I brought cards if you don't know me and need my phone number. All I need is the person's name, address, and social in which to find out if they're able to be bonded. Something that I keep running into here lately is, say someone comes to court and the judge has made all these very detailed specifications in the order and the attorney is going to have to come back with the order. They swear in the personal rep in the clerk's office and off goes everybody. And then when the attorney comes back in with the order, it's setting a bond and the personal rep has not filled out any paperwork whatsoever. The clerk has no idea if there's going to be a bond. So please be proactive in saying, you know, if for some reason you know that you're going to be coming back with this order and there is going to be a bond set, that you have your personal rep fill out the pertinent information, the application that we have on file, as well as signing a blank bond in some cases. I can easily give those to you when you're there so that when you do come back with the order, I can just automatically hand off the bond and everything is taken care of. Also, if a bond is closed out within the first 12 months, you do not unfortunately get a refund for any of that portion back. However, if they pay a renewal, and you close it out, even if it's a month into it, you are going to get the majority of the money back. Two things are important. I need to be notified if something happens, as far as if you reduce a bond, if you increase a bond. You can't just come in with an order to increase it, you have to have a signed additional bond. A lot of times the attorney can sign on behalf of the client, but I have to be notified. It's not the clerk's office responsibility to let me know these things. So I ask you very kindly if you would, please let me know if something changes with the bond so that, I can get you whatever paperwork needs to be done. I can invoice and so things. Also, in the case of you've paid a renewal on the bond and the bond closes, I've got money sitting out over here that needs to go back to somebody. And, if it's 6 months or a year down the line and I've gone and tried to renew, send out a renewal and found out that the bond was closed, it's a lot of times the estate bank account's already been closed and we run into an issue with this money that's sitting out over here. I've had people who don't normally practice probate who have come in and, I've sent out a bond renewal and they're like, oh, we don't need that anymore. And I've said, well, it's not your job to tell me you don't need it anymore. It's the judge's job. The bond is there until the judge says otherwise. Another thing that I've run into is, say, the personal rep was discharged and it says specifically in the order that, Gary Harshman is discharged as personal rep. However, he will file a final accounting within 30 days of the date of this order. And I have found that it's just sitting there in limbo. It's open, and the personal rep thinks it's closed because the way that the order states it, and they have not filed a final accounting. So that is another thing that is important, is if your personal rep has to come back in 30 days, somebody needs to be in charge that says, go back and get this filed so we can get the bond released again. So also from time to time, I will allow somebody to backdate or non-proton the release of a bond. But like I did a situation yesterday where the bond was due December 1st of 17, and now here it is the middle of May, we're getting ready to close it. Well, the bond was due back in December, and that really needs to be paid and then a refund issued rather than going backwards. It's somebody needs to be on the hook for it, and the bonding company doesn't need to just hold on to this and then allow us to backdate the release of it. Also, one last thing. I can accept money for bonds in the forms of cash or checks. I don't care who pays for the bond as long as, that payment is good. We don't have a way of accepting credit cards, so I'm just kind of saying that once again. Does anybody have any questions, or have I explained it well enough? Go ahead.
Pre-qualifying?
Yes.
Is that a phone call, email, form? What's the...
Phone call or email, it takes you 30 seconds, literally. So, yes.
In the situations where a refund may be due a bond premium,
Mm-hmm.
is that paid to, and let's say you have a situation where the estate account is closed, is that paid to the attorney?
Unfortunately, it is paid to the person, whomever is bonded, the refund goes back to that person. So we don't have a way of changing how that goes because in our system it's put in through either you being a personal rep as the attorney or your client, so. Yes.
How does the bond work on the small estate?
Small estates, it's open and closed the same day as far as the court system, but the bond is held open for 1 year, and you don't have to do anything to close it. So, and we don't run credit on small estates. Small estates are just, anybody and everybody now can do a small estate, so.
Okay, and then on the regular full estates, the renewal notice is sent to.
The renewals notice I sent to both the personal rep and the attorney, just in case the personal rep is moved and I have no idea how to get in touch with them. And I've been taking emails for the last year and a half on the personal reps so that I can send them an email, because usually those don't go away, so. Any other bond questions? Yes?
Do you have a bond premium schedule for different amounts to estimate?
Unfortunately, I don't. It's a scale, and it's like for the first 25,000, it's this much. For the next this much, it goes up. The higher the bond amount, the less amount there is in between thousands. But I don't. I can give you some ballparks if that helps.
What's the minimum amount for so the minimum is 25,000?
Minimum is 18,000, which is $125.
Okay, no more questions on bonds? Oh,
What do you need a bond on a Tuesday?
Just call them. They can do it. They can do a bond on a Tuesday, no problem. If it's somebody, meaning the clerk's office, can do it just fine. It's a lot of times, it's a situation where I'm at our main office at Clark Tower on Tuesdays, so I don't physically get to sign a bond until I get there on Wednesday. However, you can still get everything you need. If the person is pre-qualified, you can, I usually send an email back to the attorney and tell them this person is qualified. You can take an email down, or the clerk's office can physically just call me, and I'll tell them, it's a verbal thing where it's good to go, and they can give you letters and everything else that you need. So.
I'm
Yes.
sorry for the exceptions of the county. The judge is the only one who can bring the exceptions. You all have any leeway?
No, depending on the exception, I can clear it.
Okay.
Yeah. Depending on I meant to talk about that. Depending on the exception, I can clear that, which is best to try to get the exceptions cleared so you won't have to go to court. So as far as like court costs, of course, you come in and pay. If I give you an exception for no checks or something, just bring the checks. So if you can clear the exception, that'd be best. It's best to do it before, like the day before or the day of. Some people do that. That's okay if you have to, but if you can clear the exception, before, you can do that. But yeah, I can clear the exceptions where you won't have to come to the court. You just basically have to do whatever the exception is. You just have to correct it.
I think I had one for the judge, I had to report on it.
yeah, if it has to do with anything like 3 years, or it's been over 3 years or more, we can't clear that. You can't come and explain to us to clear that. It has to be cleared through the judge. Now, you can even clear paying out fees and stuff if you want to go get a petition order signed to give you permission to spend those fees, then we can clear that up for the hearing. So pretty much everything can be cleared up except for the time.
I have a question about exceptions. I haven't had this come up and don't know the procedure. What if an exception to an accounting is filed by like an interested party? Is that something you have a meeting with them and attempt to resolve it, or how does that work?
Okay, so so once you file the exception, they have like this right on the states, right? Because really with the conservatorships and guardianships, I can audit those right out. You don't have time really to accept to that. But as far as like with the estates, you have like, the heirs have like 10 days or a little over 10 days where they can come in and object to the accounting. And so once they object, that's an automatic exception that I put on there. So if an heir or anybody else comes and, because it's the attorney's job to make sure all the heirs get a copy of that of that full accounting that, they found. So if an error, somebody looks at the accounting and be like, this not right, or they spent too much money, they can write a letter or type a letter and come to the court, file it, and I file it as an exception to the accounting. And so when I do my exceptions, even if it's no exception that I find, then I will automatically make that an exception, and then you automatically have to go before the judge. The judge's secretary will give a hearing date, and so it'll automatically be a hearing to go before the judge to clear that exception.
Gary, okay, once you get back to Beth's question on bonds on Tuesday, I've never thought about it, had it happen. Is there anyone that you've got appointed that is a point of contact when Holly's not there?
No, any of the clerks will contact her.
Yeah.
To go back to that, Polly works 4 days a week usually down at the probate court. With the exception of just Tuesday, she works out of her other office. But we can make contact and get a bond pretty much any time. Even if Polly's out, there's people in Douglas Career who can back her up. But I did want to go back, I did have some papers printed here that I wanted to bring to your attention. We do have a checklist for accountings for our estate, conservatorship, guardianship on our website that you can go pull up, and then you can kind of do that checklist. It's good, good average, you're not going to have those exceptions anyway. Then on the certification of notice, probably everybody's following knows what that is. That date is going to always be on a Friday. Okay, and you got to give them at least 10 days out. We like to give them 2 weeks. So if you come in today, it will be not this Friday, but the following Friday we can put in. So, because I know a lot of attorneys like coming in with their sheets all typed out, looking nice and great. We love that. But if you put your date in, that's fine, but it needs to be a Friday. Okay. And the only other one was the our cover sheet for our county. As you know, the 2 places highlighted, that's the county dates that needs to be on this. It's from January 1 to December 31st. But it's real important for us to have those dates. So we know, 1, you're within that time frame. 2, we can look at that ending period and it should match with your ending statement. If it's through, November or whatever, then we should be able to go to that statement and find that fairly easy. So if you've been in the habit of not doing that, make sure we really appreciate it if you do that. And the only other other things that we find that doesn't get checked off, whether you want the accounting to come back and confirm it, or you want us to send it through. If you mark it, either way, whether you come back and confirm it or we send it through, if you don't ask for fees, there's not a cost. Most of the time, if they mark don't send it through, it's because you were trying to get a fee, which I get that. Then you mark that, and you come back, and then there will be a fee for that order, with fees involved for $12. Now, even if you mark that you do not want us to send it through, if it goes past 60 days, guess what? We're going to send it through. That doesn't mean you can't, because it's not going to cost you anything anyway. So if you plan on getting fees, to come in and do an order for your fees anyway. You're still going to be doing the same order, costing the same amount of money. But we've had some say, well, I'm marked, do not send it through, and it's, 4 months later. We just try to keep these things going so we do the process. But anyway, I want to bring those forms up. Yes.
On the checklist for conservatorship, the third from the bottom, statement of fiduciary as to physical or mental condition, is that a new form? The third from the bottom?
Third from the bottom.
Statement of fiduciary as to physical or mental condition of a disabled person, is that something that has to be filed with the annual accounting?
Well, it's supposed to be filed. I mean, some people may not always have it, but most of them do. It really needs to be filed.
So it's a separate statement?
Right, it's a separate file.
I guess. We have a judge here still in the house. Let's ask. How important is that, Judge, for them to have that statement in there?
Actually, that statement is required by law to be
There it is.
completed. But a lot of times we don't object to it not, but I will ask about the respondents right then and there once you're before the court. 'Cause I want to know how the respondent's doing. But yes.
Thank you. Did that answer your question?
Regarding that, 20 years ago, I was handling a conservatorship. It was very little money. The conservator was a conservator over the property as well as the person. And so it got down to the point where Judge Southern said there's no longer any reason to file with counties, but they wanted that statement filed every year just to let the court know that this person is still alive and still coming.
Right, kind of like a status update. Now, also, our court has, and Richard does a great job with this, we have the ability to take money in, especially on minors, that could save you some money, and even on conservatorship, if you got X amount of money sitting over here, and you don't want it to, I'll call you off the law here, if, say there's a few $100,000, and you know it only is gonna take X amount for this individual to live a year, you can turn that money over to the court. Now, we only invest it in CDs, safe investments. We're gonna hand you back as much as you hand us. We're not gonna hand, we're not gonna go out and play the stock market or anything. Our goal is always give back what we brought in, okay? So that can work in your advantage, being able to reduce the bond maybe down to a lower amount, which costs you less. And just turn that money over to the court. And you can even draft it where the court can pay out, $50,000 a year to the personal rep in order to take care of the next year. I mean, it can be drafted where, I know someone mentioned about some trust earlier. That's one way of getting around. It's not a trust. It doesn't make the money trust. But once the money comes into probate, you can rest assured it's not going anywhere without an order. So once we receive it, used to in the past, there was an order when the minor turns 18 or majority that we could release the money. We don't write those orders anymore. They have to make an appearance with an attorney. Petition to either get part of it, any of it, or all of it. So that money is a safe place to put it. Any questions about the clerk's office at all?
Yes, question for cases where funds are being held for minors till they get 18, like, let's just say, for example, if the child, when they get 18, they don't know nothing about the money in the court, and let's just say they don't have no more relatives that advise them that they have some money in court that they can get. Do they, like, y'all notify them, or do you just sit there?
It says it till we get the word release it. Yes, it really does. And since you brought that up, it's real important on the minors. If you want the money invested, we don't invest the money unless it's ordered for us to invest it. We really don't do anything with this money unless we're told to do something with it, whether it be invested or sold. If it is ordered for us to invest it, which right now is going to be about 2.5% interest on CDs, we have to have the minor Social Security number in order to produce the interest back to the personal rep attorneys or whatever. But we cannot invest the money, even though the order says invest money, until we have proper documents, which is Social Security. So even though you put in there to invest, there's forms that Richard has that he'll have you fill out. Skip putting on the Social Security number if you don't know it. We really don't obtain those numbers anymore. But for investments, it's critical that we would get that number.
There's not any other questions, we'll go ahead and guess. Good. Okay.
Thank you.
Gary?